Good afternoon, everyone. Good afternoon. Okay,
Hey, good
so
afternoon.
let's get started. Uh, Everybody have a weekend that at least did what they needed to do, what they wanted to do. I know that everything is what it is. So, how are we doing today, guys?
We're
Doing
all
pretty okay. Yeah.
fine, thanks, sir.
Good, good, good. Okay, so today, um, we're going to be continuing our discussion of occupiers' liability and the uh, conditions under which owners or occupiers of premises can be held liable. And so the first thing that we're going to do is we're going to, you remember that on Wednesday we talked about the categories of visitors, both under the common law and under the statute. And we talked about how we define an occupier. And today we're going to discuss a couple of categories of visitors that are treated differently under the law. And then we're going to talk about what constitutes a premises for the purpose of premises liability. It is possible, as I was preparing today's lecture, it seems like the material was a little thin. But so it's possible that we'll wrap up a little early if you guys are sort of bump on a logging it. But if you're engaged and you're participating and you're asking questions, then we'll go as long as we need to go up to full time. So last Wednesday, you guys may recall that Rudolph asked a question about children as visitors, and I told him that we were going to put off that conversation. Well, now we're here, right? And as Rudolph pointed out on Wednesday, right, children are different. Children are treated differently under the law because the idea is that, they may not have the same appreciation or understanding of danger that a reasonable adult would, right? And so at the common law, right, at the common law, there was a duty of care owed to children, even if they were trespassing. Okay, even trespassing children were owed a duty of care under certain circumstances. And those circumstances were if there was what the common law called an allurement, or sometimes the cases just call it an allure, or if there's actual knowledge. So the property owner knows for a fact that children access the property. Okay. Under these circumstances, the occupier has a duty to take reasonable care to prevent children from accessing dangers on the property. Okay, so there's a specific, this is a pretty narrow slice of cases, right? We have children who are trespassers, but either there's some sort of alluring thing on the property or there's actual knowledge, and then there's a duty to take reasonable care to prevent children from accessing the danger. Okay, what do these things mean, right? So the first thing is we know what trespassing means. Okay, we know what actual knowledge means, but what is an allure? Well, an allure is basically just anything that if you look at it, you go, oh, hey, a child would be interested in this. Okay, so if you have a swing set on your property, or a trampoline, or a sandbox, I suppose, right? If we want to sort of stretch the issue. There is one case that the materials mentioned that I want to call to your attention, which is the Glasgow Corporation versus Taylor case. And in that case, the allurement was actually a holly bush. Okay, so you guys may not be aware of this because American holly doesn't grow down here. It requires a colder climate. But American holly bushes have these very shiny, bright red berries, and they will kill you dead. Like they are utterly poison. And so these bushes were held in the Glasgow Corporation case to be an allurement. So the child went onto the property, was eating the holly berries, and was harmed by them. To be perfectly frank, I don't remember off the top of my head whether the child died or not. But those bushes, because of the attractive nature of the berries, were held to be an allurement. Okay, so this is a very common sense sort of thing. Okay. I have a private question. Is it related to attractive nuisance? The doctrines are similar. I would say, we haven't talked about nuisance yet in this class. We're going to talk about nuisance after we finish with occupier's liability. It seems there's going to be some similarities in those two doctrines, but they're not going to like perfectly match. Okay. So but that's what an allurement is. Okay. It's basically it's a very common sense sort of inquiry where you sort of look at the thing that the child was interacting with and you go, well, yeah, I would expect a child to be sort of attracted to this thing. Excuse me. And so those are the circumstances where even if the child is trespassing, there's still a duty of care owed. What does it mean for the duty of care to encompass reasonable care to prevent children from accessing the danger? Well, it means, putting up fences. Warning signs, probably not going to be enough because the courts recognize that not all children can read. For the person who asks, repeating the case name, it's the Glasgow Corporation versus Taylor. Okay. Private question. Some children are attracted to rocks. So is there a scope for this? I mean, there is, right? It's not going to be a subjective inquiry. It's not going to be, was this child attracted to the thing? Okay. It's going to be, would a reasonable person expect a child to be attracted by this? Okay. So I think, I think that's a fair question. But the doctrine does not sort of encompass anything that any child may look at and go, ooh, neat, and chase after. It's a private message that I don't understand. Going to their parents. What does that mean? What are you saying? I'm afraid I'm afraid I still don't understand. You've said going to their parents to remove liability. I don't know what that means. You got to explain that. Okay, that's fine. Okay. Um, so what was I saying? Okay, so we've discussed, we know what trespassing is, we know what an allurement is, and we know sort of what the scope of the allurement definition is. We know what uh, what actual knowledge is, and we've discussed what the reasonable care requires, right? So again, warning sign, not enough. Fencing off the dangers, plenty, right? Preventing children from accessing the property also meets the reasonable care, right? So you fence up the whole property. Okay, so what questions do you guys have about the duty to the child trespasser? So a private question, when we say reasonable care, do we mean the same as in negligence? Yeah, basically, right? And so this is the connection between negligence and occupier's liability, is that in most cases, in occupier's liability, the duty of care is a reasonable care standard. The exceptions are contractual visitors, and certain types of workers that we're going to talk about in a minute. Okay. And again, right, I want to encourage you guys, if you have to use the chat, I want to encourage you to use the chat. Like, speak to your classmates, don't send me private messages. If you do, I will respect that. I'll answer it privately, but you're asking, you guys ask good questions. Your classmates should have the benefit of that. So okay, so if there's no other questions about the child trespasser, let's talk about the lawful visitor, the child lawful visitor. Okay. Gemma says, I'm thinking that if the child is under a certain age, their parents would have some, if not all, responsibility to keep their child from wandering off and eating something strange. And this brings up a really helpful, I think this is a really helpful transition to the lawful visitor, right? Because here's the thing, right? The child trespasser is one who, by definition, is not under a parent's control, right? Because if the child trespasser is under an adult's control, the occupier can treat them as if they were the adult, right? Children who are under the control of an adult don't exist as far as the law is concerned. Okay. So Gemma's right that there are points where the responsibility transfers from the occupier to the parent. But when the child is trespassing, they've already sort of gone beyond the control of an adult. Okay. So with the lawful visitor child, right, there are some circumstances where the duty of care is actually heightened. Okay, so for example, the Jamaica statute on occupiers' liability specifically says that occupiers are under a responsibility to recognize that children have a lessened capacity than adults. And what that means varies. Okay, what it means to recognize that lessened capacity may be different from circumstance to circumstance. So, for example, an occupier can take the position that children are not permitted on these premises unless they are accompanied by a parent or guardian, right? That's a perfectly legitimate way to handle that responsibility of understanding the lessened capacity of children. Okay. Let me finish this point and then I'll get to the questions in the chat. So that's absolutely a possibility that you can say, kids, you can't come in without your parent or guardian. Okay. One of the things that it may mean is that if there is some sort of allurement on the property, that the occupier has some sort of responsibility to remove the allurement or to prevent children from accessing it. And it may mean, like I say, that fencing or warnings are appropriate, but there are cases where the courts have said, look, there's some dangers that are open and obvious, and if you've taken reasonable care, there's no more that you can be asked to do. Okay, so let me address these things that are in the chat. Kirsten asks, what about children who trespass at the request of their persons? For example, their parents instruct them to go into their neighbor's yard to steal mangoes. Well, so I think that there's a couple of issues here. The first one is, why are the adults telling the kids to commit crimes? But that's a different issue, right? Let's roll with the hypo as you've presented it. So if you've been in, it seems to me that the duty to the child trespasser is the same regardless of why they're trespassing. But the ability of the parent who gave the child instructions to recover may be limited. So there may be a situation where the child has a claim, but any recovery has to be held in trust for the child and cannot be put to the benefit of the parent. That's an issue related to trusts, and that'll be something that you'll talk about in your third year if you take the law of trusts with Dr. Yearwood. That's sort of my just sort of spitballing on the issue. I don't have a case to give you that would answer the question definitively.
Sir?
Yes, go ahead.
So if a ball goes in the neighbor yard and the child goes to get it and gets bitten by a dog,
is there more to this?
No, that's it. Like, who would be liable?
Well, again, right. So we've discussed on a couple of occasions that dog bites present other issues where the owner may or may not have a duty of care related to that, depending on what breed the dog is, whether the dog has a history of biting people. But certainly, if we assume that that the owner was under the duty of care, right? Either because of the dangerous breed rule or because the dog had a history of biting. There's absolutely a duty to take reasonable care to prevent the dog from biting. The question becomes what at that point becomes what constitutes reasonable care. Okay, so I think that it is plausible to argue, right, that, you know, if speaking from the occupier's perspective, if you've put up, you know, if you've fenced in your dog and kept them, you know, sort of, you know, within your property and made the fence difficult to climb, you know, a 5 or 6 foot high fence, I think that you would probably be able to say, look, you know, I did everything I reasonably could do to prevent children from being endangered here. You know, this determined, you know, little boy climbed this fence that was intended to protect him. And, you know, it's tragic, but I haven't breached my duty. And I think that's an argument that you can make. Um, so does that answer your question? Um,
Yes,
sorry.
sir.
Okay, great. Next, in the chat, a couple months ago, a child was found floating dead in a pool of an unoccupied house that is still under construction. In this case, would the owner be liable? So I keep feeling like I should be adding content warnings to this class because we really do come across some very disturbing fact patterns in this class. And this being one of them, right? But we so the house is still under construction and the pool is already full of water. Boy, that seems like a really bad choice. Like it feels like filling the pooling should be the one of the last things you do. But you know, I'm not an expert on these things. Perhaps there was a perfectly valid reason for doing it that way. A couple months ago, a child was found floating dead in a pool of an unoccupied house. Would the owner be liable? I would say probably so. I think that I would feel comfortable classifying a pool as an allurement and that the owner had a duty to take reasonable care to prevent the child from falling in. The question at that point for me would be, what did the owner do to prevent it, right? So that's sort of the missing piece in all of these stories is what actions did the owner take to actually prevent children from accessing the property. Tamara asks, in a case where children walk through your yard to get home after school as a shortcut and get injured, can they or their parents take action against that? You know, I guess, you know, there's nothing in this question from Tamara that suggests that there's an allurement. So that's going to turn on the actual knowledge question. So if the occupier knows that the children are crossing the yard, then there is a duty to take reasonable care to prevent them from accessing dangers. But if there's, but the other thing, the thing that I think is important to remember is that there's no duty of care to make the premises safe. Okay, and there's no warranty. You'll recall, you know, on Wednesday we talked about the warranty owed to contractual visitors. There's no warranty to a child trespasser owed here. Okay, the duty of care is to make sure that that a reasonable child cannot access the dangerous things on your property. Okay, but like if a child is trespassing and they trip over their own feet and they fall and break their ankle, no, you as the occupier have done what is necessary to protect the the children from dangers in that circumstance. So does that, I hope that makes sense. Let's see. Oh, these are some questions related to the abandoned house. Wouldn't we consider how far away from neighbors the property is? Is the property far away from where children are? I mean, I think those are things that are going to play into what reasonable care looks like in this circumstance. But I think that, you know, the presence of an allurement is a serious problem for an occupier, right? If you see one of those, if you have one of those things on your property, like that's the duty of care is on you at that point, and you have to take it. You have to, you know, take it seriously and make sure that you have, you know, done what's necessary to protect children who may come onto your property. So you know, no bear traps under the swing sets. So what other questions do we have about children as visitors or as trespassers? Brianna says in the Caribbean, we walk through yards a lot for shortcuts. And look, I'm not telling you don't. I'm just telling you that there's that the law doesn't necessarily protect you when you're walking through somebody's yard. Kirsten asks, what if there's no allurement, in so to speak? In other words, there is nothing that would reasonably attract a child they just venture in. Okay, so that's the other side of the child trespasser doctrine, right? Remember, we said that child trespassers are owed the duty of care if there's an allurement or if the occupier has actual knowledge that children enter the property. Okay, so that would be the other issue is, does the occupier have actual knowledge? You know, that's the other situation where that happens. Keandre asks a question that I am not going to answer because this is not real property. Here's the real answer. Okay. Keandre asks, isn't that considered an easement when you walk through a place that is commonly used but is part of somebody's property? Easements are discussed in Real Property 2 that you'll take in semester 2 of next year. But the very short answer is that there is a particular set of circumstances under which an easement, which is a right of access, can be created basically through use. Okay. But that is something that you'll discuss next year in Real Property. Okay. So what other questions do you guys have about the child trespasser doctrine in occupier's liability? You can ask other questions. I don't promise to answer them.
Sir, I came in late, unfortunately. So can you like do like 30-second overview of what the doctrine, like what you said?
Sure. Okay. You remember we said on Wednesday that the only duty of care owed to a trespasser is the duty of common humanity, which, as near as I can tell, basically means you can't sit there and watch them bleed to death. If a child is trespassing on your property, there is a duty of care. that duty of care is invoked if there's an allurement on the property, which just means a thing that attracts children, or if you have actual knowledge that children are coming onto the property. And that duty of care is to take reasonable care to prevent children from accessing any dangers on the property. Okay, so that's the
Okay, yeah.
doctrine. That's the doctrine. If you want to know the details, the recording of this lecture will be posted towards the end of the week. Okay,
Okay, I understand.
no problem. All right. What other questions are there about child trespassers or child visitors? Nothing else? Okay. So let's move on and let's talk about the second class of special visitors, right? For whom the duty of care is different. And that's, Mystique says, up to what age would you be considered to be a child trespasser? The answer is probably all the way up until the age of majority in your jurisdiction. But there may be a, if, for example, if it's an actual knowledge case and not an allurement case, and the property owner knows that we have teenagers trespassing, not, babies, then it's possible that a court could find that a warning sign met the duty of care, because we can assume that teenagers know how to read, right? Maybe, right? That sort of becomes a fact-driven analysis, and I don't want to get too far out in the weeds on it. I want to sort of stay focused on the principles here. But the duty of care extends all the way up to people of the age of majority, even if what fulfills the duty of care may change. So, all right. The other category of special visitors that we're going to talk about is workers. Okay. And the answer and the issue with workers is that the courts think that it is reasonable to say that, workers are there to do a job and they know how to do it. And so risks associated with the work that they are there to perform, there's no duty of care, right? So the example that I came up with is, if you call someone to repair a broken staircase, right? Your handyman is not going to be surprised if the staircase, breaks under them and they fall, right? That's a risk that they should be able to appreciate and expect and take their own care to avoid. And so you, as the occupier, are not on the hook for that particular risk. However, if you call someone to repair, say, your dishwasher, which I am currently waiting on someone to come and repair mine, and the ceiling of your kitchen collapses on them, well, they could not have foreseen that particular danger. They could not have anticipated that that would be a problem, and you are responsible for that particular for the harm from that particular injury. Okay, so and in fact, I want to be clear that in Jamaica, and only in Jamaica, right, the Barbados statute does not contain this. There's an explicit statement that as long as you don't try and direct the worker in how to do their job, that you have the right to expect them to exercise their own appropriate care in doing the job. Which means that in Jamaica, if any of you are from Jamaica or are considering practicing there, right, the common law doctrine has been codified. And if you bring a handyman in and you say, here is the thing that I need fixed, make it do, and then you walk away, if they're injured by the thing you asked them to repair, you're not on the hook. Okay. So what questions do you guys have about workers as visitors? About the difference between when you are subject to a lessened duty of care and when you are subject to the contractual visitor warranty? So Mystique asks, what if a builder steps on a piece of wood that a nail is protruding from? I guess we're assuming that the piece of wood is in some way associated with the thing that the builder is there to fix. Is that, yeah. Then probably there's no liability because that's part of the work that they're there to perform. And so they are expected to exercise the appropriate care. Excuse me. If there's a piece of wood that with a nail, protruding from it, that is just like, that's your burglar weapon, a big club with a nail in it, then probably you're on the hook, right? Probably the occupier is liable if the builder steps on it and injures themselves. So do you see the difference between the two scenarios?
All right, so sir, I kind of lost.
Okay.
So what I am understanding this to me is, for example, on the West Coast right now, I live on the West Coast, and they're doing work on Highway 1 or whatever the case may be, right?
Mm-hmm.
So you're saying that if there's a worker who happens to step on a piece of board with a nail protruding on my property that I would not have budgeted for in that sense or whatever the case may be, that there's a possibility that I may be liable for that. Let's say that they end up working in a particular area, or I had the wood close to, I don't know, a main that they were working on that nobody really travels past or whatever the case may be, and then they end up stepping on it. How would that work?
I'm not sure what you're asking. Can you say just a little bit more about this?
Because, okay, let's say they're working with gas or something, and they need to come across my property and go in an area that I have thrown the wood with the nail protruding on that nobody walks on because it's not in their general pathway.
Right.
They end up stepping on that piece of board and injuring themselves because they would need to work on the gas main that they are working on. How would that work?
I mean, it seems to me that under the occupier's liability doctrine, you might be liable, but the issue then becomes, right, all that means is that you are subject to the usual duty of care. Okay. And what duty of care is that? These are not contractual visitors because they don't have a contract with you. They're working for the government on the water system. So they are an invitee. So what's the duty of care for an invitee, right? An invitee is owed to be reasonably aware of unusual dangers and to prevent harm from them. So would it have been reasonable for you to say, well, no one goes over there? Maybe, right? Then it becomes a fact question. So does that answer your question, Michael?
I think that I am understanding that you are, I think you're trying to say, or no, from what I'm understanding, if I would know that this is an area that nobody passes or whatever, but in this special sort of circumstance where there are people working, it should have crossed my mind to move the wood because there may be a possibility that they need to pass that area in order to do their job?
Yeah, I mean, I think that's a reasonable argument for the plaintiff to make. Is it going to fly? Who knows, right? Maybe the court buys that argument. Maybe the court buys your argument as the occupier that, it's not reasonable to expect me to police the whole yard, and this part of the yard is extremely low traffic, and so it seemed like this was a perfectly fine place for me to store my wood with a nail in it.
But my
Why-
issue in this circumstance is not so much the occupier's liability, but given the nature of the job of, for example, a construction worker, and the kind of things that they need to be around, the kind of protection that they need to wear, et cetera, et cetera, et cetera, would it be fair to say that they should have budgeted for any kind of circumstance like that because the nature of their job requires them to take into consideration unforeseen circumstances and hazards?
I mean, I think the answer to that is that no one is ever required, unless it's a strict liability situation, no one's ever required to take into account unforeseen hazards and liabilities, right? That's the nature of what the duty of care is that it requires us to protect against things that are foreseeable. But things that are unforeseeable or unforeseen are by definition do not fall within the duty of care. So I think, it seems to me that what you're asking is really a question about workers' compensation issues and whether the employer has a responsibility that would extend to this. And the truth is that, we've talked a very little bit about workers' compensation in this class. I know that, Jamaica has a workers' comp scheme, and that's the only one that I'm aware of. There may be others, but I don't know of them. So it seems to me that that the situation that you're asking about within the scope of occupier's liability, right, which is what we're discussing, is fairly straightforward. And it seems like what you're trying to do is put it into some other body of law, which may be a better fit for it, but is not what we're discussing. So does that help?
Yeah, I guess the straightforwardness of, like, as you would say, as you said just now, the straightforwardness of occupier's liability, it seemed as if there was more that needed to be added, because it just seemed a little bit like, you understand what I mean? It seemed a little bit incomplete in my mind.
I mean, not everything in law has to be complicated. Sometimes things can be simple, and I promise it's okay.
Okay.
So, but I certainly understand how at this point in y'all's education, you guys would be looking at this and going, I feel like there must be more to this. Sometimes there is, sometimes there isn't. Okay. So Selena asks, if one doesn't have the necessary personal protective equipment and they come to work and get injured, the occupier would not be liable, right? And I mean, I think you're probably right. I think that the occupier would not be liable. The question becomes why. Why not? What do we think? Why not?
Well, sir, you mean in general?
Yeah, I mean, I agree with you. I agree with the folks in the chat who are saying that the occupier is not liable under the workers, under the duty of care owed to the worker. My question is, why not? And Selena says, if you're coming to do a job and you know the risks, you should walk with your PPE. Exactly, right? Having the appropriate protective equipment is part of exercising appropriate care in doing the job. And that is the duty of the worker, not the duty of the occupier. Now, if it's a work site and the employer has a policy of providing protective equipment, that may change the calculus. Okay. But the exercising of appropriate care belongs to the worker within the scope of the job. Okay. All right. What other questions do you guys have? Someone asks me privately, is this like independent contractors? The answer to that is this duty to workers is owed, the duty for workers and the duty to workers is owed regardless of the worker's status. So employees are expected to exercise appropriate care. The employer is expected to exercise to fulfill its duty of care, but it also, even if the workers are independent contractors, they're expected to they're expected to meet the duty of care as well. Okay. So what other questions are there?
Sir?
Yeah.
So when you go in a car park, there is a sign saying that the person who owns the parking lot is not liable if your car is stolen or broken into. Are they like, are they really not liable, or?
What do you think?
Well, I remember you were talking about, like, if you go on an amusement park and you sign saying that, you give, well, the amusement park is not liable if you are injured, that doesn't count. So I was thinking that if your car is stolen, that yes, they are responsible to some extent.
So let's sort of make sure that we understand the scope of what we're discussing in this. The first one is, the issue of let me give you the express consent and exclusion, right? So that's the issue where we are, that's the defense of, we put up this sign that said we don't accept liability. The issue with that is that you can't waive someone else's negligence. Okay. So now we sort of, we transfer this to the occupier's liability, right, with regard to the car park, and we ask the question, what is the duty of care that is owed to the users of the car park? Well, the first piece of that requires us to know, are they licensees or invitees or visitors, right? So in Barbados, we just have visitors, and we have a statute. So what is the duty? So someone asks privately, aren't they contractual visitors? What's the contract? So this is a paid car park. Okay. So that's a different kettle of fish. Seems to me that that's a different issue than the ones where, you know, the public car parks that have the signs that say, you know, no liability is accepted for thefts, right? This person says, I thought all car parks would have to be paid for. I mean, there's that's a perfectly reasonable assumption. But there are absolutely like public car parks in various places, right? And there are places where the state provides parking to allow people to access things that they want people to be able to access. So, all right. Or yeah, Selena says, or like grocery car parks, right? Same deal. Does the grocery store, are you a contractual visitor to the grocery store? No, you are not. You do not have a contract, right? And so can the grocery store disclaim liability? Certainly not for their own negligence, but can they disclaim liability for other people's actions, such as that would fall under occupier's liability? What's the duty of care? These are the questions that you have to ask when you're analyzing these types of things. All right. So we are out of time, but we'll revisit this as the semester goes on in tutorials. And yeah, so we'll see you guys over the course of the week. And at the very latest, we'll see you on Wednesday. And I'm going to let you go, and I will see you guys later. So take care and bye.